Hello, good evening and welcome to Law and Order once again. Today we're going to take a topic about the lawyers themselves. That is, we're simply going to title the topic as what is the role of a civil lawyer. My guest today is an expert civil lawyer. He's been in practice for 30 years and he is 4 generations of law in practice. He's no stranger to our studios. He's been here before. Mr. Fernando, attorney at law. Ian?
Yes.
Was my introduction correct? 4
Correct.
generations of lawyers.
And I think the 5th generation is trying to join law college.
That's very good. Okay. We have a lot to cover on the topic, I said.
Yes.
I know it's a too broad a topic for 25 minutes, but let me straight away get to the first question, which was my introduction as well. What is the role of a civil lawyer?
A civil lawyer is a person who handles all civil work, mostly under the Civil Procedure Code. If I put it in a very nutshell, it's a lawyer who handles anything other than criminal work.
Right.
And labor tribunal work, I would say. So he is governed mostly by provisions of the Civil Procedure Code, the Partition Law and Rent Act and acts like that, and do matters of civil interest.
Right. So the difference between a criminal law and civil law, if I were to ask, what would that be?
The criminal lawyer is a person who has to administer his law under the penal code and the various other acts that constitute acts by the government of Sri Lanka, which are of a criminal nature. So that's what the role of a criminal lawyer will be.
Right. Now, sometimes the same client comes to you at different points. My question to you is, if a client comes to you and you represent that client or advise that client, can you go and appear on a different matter or advise another client against this particular person?
Quite right.
Yeah.
First, a client comes to a civil lawyer for a consultation on a civil matter. And once you take a retainer and you're going to give him some legal advice, you have been already retained in that particular manner. So you have to give him the advice on that matter. But if some opposing client of his comes and retains you in a matter opposing the client that you have already given some instructions on matter A, you cannot advise this other client. But on matter B, for example, if he's having a divorce case and you are advising him regarding his divorce case, there's certainly no stopping you from being consulted to appear against him in a case where he is the employer of a company and you are appearing for the employee, because those two matters are distinctly different. If they are distinctly different and there is no conflict of interest, that is the main point. There is no conflict of interest, you can certainly advise.
Right. Now, when civil lawyers get prepared for cases, what would you see in your 30 years of practice as a basic or essential preparatory work for a civil lawyer before he starts a case?
You should have a detailed consultation with your client and ask him to enumerate the whole incident effectively in writing, because then he would remember what he had said at the consultation, and also you will be able to recall what he has said at the consultation whilst the case is going on. So in that few minutes of consultation that you have with a written document, you will go through the matter very quickly to ascertain what the redress the client would need. And therefore, when you are retained in that matter, you will advise him what the next step would be, whether he should send a letter of demand regarding his matter, or whether a notice must be sent in terms of the law for whatever civil matter that he wishes to pursue.
Right. Now, when you say, this is just going a little bit deep, when you say the client, you have a detailed consultation, preferably get the matters in writing, do you have to warn the client or tell the client that you have to tell the truth to you, otherwise you cannot defend, or is that not required to be told by our law?
There is no specific requirement, but it is a necessity for the lawyer to know his case, whether the depth of his case, whether he has a positive case or a negative case, or whether he could make a negative case positive. So that is up to the lawyer's experience, and of course the client has to be bona fide truthful at the consultation.
Yeah.
Otherwise, halfway through the consultation, you will know that your client is not coming out with the correct truth, which will be very difficult for you to fortify your case.
Right. What happens, the client you have not discovered that truthful. We know there are massive high profile cases where lawyers withdrew from their proxy, even in recent big matters. What happens halfway through you discover that the client has not told you the truth and it surfaces in an evidentiary level or somewhere during the trial. What
Then there are
would
two
you
matters
do?
to consider, whether you are going on with the case or whether you are going to not go on with the case. If you are going on with the case, you can tell the client that his instructions as per the first consultation was this, as he has put it down in writing, and now the story is quite different, and you will get a refresher instructing you on these new matters, how you are going to handle it and how he would like you to handle it.
So there is no requirement for you to, unless you want to leave.
Unless you personally want, you can leave, but the Supreme Court rules say that when the client entrusts you with the case, that you are duty bound to go on with the case unless for personal reasons. So if there are personal reasons, then you may get out of the case.
Yeah. So if in a situation like that, this client is not debarred from hiring another lawyer?
No.
Not at all.
It's a fundamental right that he has the right under the Constitution that he can take any lawyer for any of his matters.
Yeah. Why is that you specifically have seen saying that the client should meet at least 21 days before his case, if there's a case pending against him, to meet a lawyer?
I say that the client must meet the instructing attorney and the counsel at least 21 days before the case, because in civil matters, unlike in criminal cases, there are certain documentary evidence has got to be given, some documents have to be formulated. For example, lists of witnesses and documents must be filed at least 14 days before the case. There are things like interrogatories where you can question the other side by a certain amount of questions being put forward before the trial starts at the pre-trial stage. Then there is under section 66 of the evidence ordinance a notice to be given to the other side to produce certain documents if the originals are not with you and secondary evidence has to be read. You will give notice that you are going to lead secondary evidence as the originals are with the opposing side. So on those matters, you cannot do that the day before the case. You have to have sufficient time. So it's very necessary that you need at least 21 days before the case and regularly meet your civil lawyer before the trial date of your case.
Now, you mentioned about the section 66 notice and interrogatories. Now, there is this list of documents and witnesses to be filed. What is the list of witnesses and documents meant by the Civil Procedure Code? What is meant by here?
In section 121 of the Civil Procedure Code, you are supposed to list all the specific witnesses and documents that you rely in a civil matter. So your as a civil lawyer, you have on you an incumbent position that you have to go through with your client and ascertain whom you are going to list for the witnesses and what are the documents you are going to take at the trial. So it's necessary to meet the client before that and ascertain that before you put that document into court.
Right. Now, section 121 and 75 of the Civil Procedure Code, I'm not trying to make this technical, but these are necessary sections. 121 and 75 of the CPC, this comes into play a lot. Can you explain?
Section 121 says that you have to list your witnesses and documents 14 days before the trial. Section 175 says if you have failed to do so, what are the exceptional circumstances in which you can produce a document in court with the discretion and permission of court, showing grave reason why you couldn't have it listed within that 14 days. So coming to that category, there are certain special circumstances that you should prove to the judge, and at the consultation you can then, as a civil lawyer, you can ascertain from your client why he was not able to produce this at the beginning of the case.
Now, what I mean by court commissions, I have heard this a lot in land cases and court inspections. Are these only for land cases?
As my scope in this interview is the scope of a civil lawyer, I would say the commissions are under section 120 of the Civil Procedure Code. When one has a land dispute, say you have a dispute regarding a road or a parapet wall that is abutting another person's property, it's easier for court to issue a commission to a surveyor, and the civil lawyer will prepare the necessary documents to be given to the surveyor through court, which you call a court commission, for him to go and survey the land and find out whether this parapet wall is over and above where your boundaries are, or if it's a road, whether this road is you are having the ownership regarding the road, or whether you are in possession regarding the road, the length and breadth of the road. All those matters can be formulated and found out from a commission issued through the surveyor and through court.
Right. Now, we know there were several amendments recently on Civil Procedure Code also, but the amendment that was done by Act number 8 of 2007 of the Civil Procedure Code
That
did bring
in-
some changes. Yeah.
That
What-
brings
what-
in the pre-trial stage,
Yeah.
which they have formulated very relevantly, that you had to file your list of witnesses and documents. Then the interrogatories, as I mentioned, a certain question of documents or certain questionnaires if you want to file in the case. And also if you want to discover any documents that will be produced against you in court, to ascertain the truth and validity of those documents, you can ask them to produce them before the trial stage, which all enhances your trial performance. That is why at pre-trial stage a special date is given to formulate those documents and also to raise the points of issue and admissions in the case. The issues are what need to be tried by court. Admissions are which are common factors to both the plaintiff and the defendant.
Right. Now, in this pre-trial issue that was brought in, there's a requirement made that the same judge shall not hear the trial. Is that correct?
That is the requirement, but practically it happens that the same judge hears the case because we are insufficient with the amount of judges that we have.
Yeah.
So we go on with the same judge.
Yeah.
But in foreign countries, I think that is done in a different manner, because there is a master of the role and a person who goes into those matters and then fixes the case for trial with the appropriate judge.
Yeah. So, in the pre-trial stage, I think you looking to see whether the case can be settled, right?
That is so.
Yeah. So, the judge will suggest whether it's settled or not.
Yes, and as a civil lawyer, you will advise your client that meeting at the very first trial date, which is called the pre-trial date, whether there is an opportunity to call it off and settle this matter by a give and take policy.
Right. So, what happens if the judge suggests you to settle and your one
Then-
party disagrees and it is heard before the same judge? Does that create any kind of prejudice?
No prejudice is caused, but we go on with the case, because a settlement is something out of the reach of the judge. It's between two parties. No judge can force you to settle, and no
Right.
judge does force you to settle in
Right.
our context.
Right. What is meant by in this new act by legal representation?
The new act gives you section, the act number 8 of 2017, that when you file a proxy, you can also put 2 or 3 names as legal representatives. So in the case of you having to go abroad, or in the case that you are incapacitated to come to court, the other 2 representatives in your case can muster your case on your behalf. There is no necessity to have a power of attorney, which is the normal way that one would muster your case. The representatives can come forward and carry on the case.
Right. Now, I think that cuts a lot of time on having
Cost
to come
cuts a
for
lot of time,
people
a lot
to
of-
come back to Sri Lanka for
and,
cases.
and,
per
and,
se.
and the case is expeditiously heard, because there is no stopping for dates to be given until the client returns back to Sri Lanka.
Right. Now, this section 146 talks about what is I think the role of in the sense of a trial. Now, I know it's a too broad a question, but if you can sum it up.
At the trial is the
what
most
role?
important stage, and as you would know, I say that the consultation is necessary before the trial.
Yeah.
Because if you are for the plaintiff, what you are going to give evidence in court can be given by affidavit to cut short matters, and also as a civil lawyer you can advise your client how to formulate his case in the witness box.
Yeah.
So it's very essential that you see your client, and the client plays a great role in formulating this evidence to be given at the trial. So is in the cross-examination. You have a consultation with the client regarding the cross-examination, and you would have, before he gets into the witness box, because after he is being cross-examined, according to our procedure and our ethics, you are not supposed to have a consultation with the client once he is in the witness box being cross-examined. So only questions that can be asked is to impeach the credibility of the witness and on the points of dispute. Any questions that he has to face regarding of a scandalous nature or which is not relevant can be objected to by the civil lawyer when he is being cross-examined. And in re-examination, that is formulated by whatever cross-examination questions that he has put forward. If they are not clear, it can be cleared in re-examination. And I must state that no leading questions can be asked in examination in chief, but in cross examination certainly you may lead the witness.
If I were to delve a little bit deep into this, why is this principles come into force as you see as a trial lawyer? Why?
This civil procedure code, which is coming down from Roman times, I believe, has set out the way you conduct a civil case. And as you know, if you play a game of cricket, there are certain rules and regulations. So in court also, there are sets of rules and regulations, and it has to be adhered according to that.
Right. Now, you mentioned about leading questions. What is a leading question?
A leading question is when in examining the witness by the plaintiff or the defendant, in his examination in chief, he leads the witness. For example, to say, Mr. So and so, you are the owner of these properties, and you have got several houses. That cannot be asked. You can ask whether the particular house that he owns is owned by him, and whether he has a title deed to that property, without assuming certain facts. If you are assuming certain facts, those will be called leading questions. So it's basically you have to put a question and answer when you are getting evidence in chief of the witness, without leading him as to put the answers into the mouth of the witness.
We all know this written submissions that you do file in a civil case. What is this written submission? What is it different to that than the submissions that you make on oral?
As a matter, as a civil lawyer, on certain circumstances in the case, the judge asks you to file written submissions sometime during the case on certain points of law to be argued, which you'll have to do some legal research as a civil lawyer and pinpoint your point as to prove that it's correct. Or at the end of the trial, you are asked to give a set of written submissions, both parties, which is a concise statement or a synopsis of the entire case. And if that, I think, runs into too many pages, I don't think it will be gone through very well. It's a very crisp, short and crisp to the point document that sets out your entire case on behalf of your client. And as a civil lawyer, you have a great responsibility in delivering a good written submission, because that is the root and substance of your entire case in a nutshell form.
It is said that lawyers are the only people who can write a lengthy document and call it a brief, right?
That is so. That is so.
Now, but coming into another very important question that people are getting confused is the difference between an order and a judgment. Is there a difference in this here,
Yes.
or is it the same?
As you know, when the trial is going on, there are certain objections taken, and the trial judge has to make an order regarding those objections. So that's a situation where the judge delivers an order, and on that order, if you are not satisfied, within 14 days, as a civil lawyer, you can advise your client to go up in appeal as an interim appeal.
Right.
But as you get a final judgment, if you are not satisfied with the final judgment, you have to give notice of appeal within 14 days, and you have to file your petition of appeal within 60 days from the date of judgment. That is the substance that is there in those two words as order and judgment.
Right. In whichever court, is it the same?
Whichever civil court, it is the same.
Is it the same in an appellate civil appellate courts?
In the civil appellate court, you have to go in with the same provisions. Within 14 days, you have to go in. That's after your interim any order given, or in the situation where it is a final order, you have to go up within 14 days on notice of appeal and 60 days by way of petition of appeal.
Right. You mentioned about this petition of appeal and notice of appeal. The only difference is what you said. No.
There are other differences as
What
well.
can we explain?
But the notice of appeal is just a format which gives you on what point that you are wishing to appeal in this particular legal matter.
Right.
The petition of appeal, which will come after getting the final order, is a more complex document which gives you the entire case, which would annex the entire order and the entire case record, and go up in that with the provisions of the law showing that they have been infringed by the lower court judge.
Right. Now, in your practice, you would have seen eternally people are complaining, maybe not you, maybe other people, but people are complaining of loss delays. Now, having done this job, I know you practice a large area of civil law, almost every area, which is land or divorce or, civil injunctions or whatever. What are the causes you see in Sri Lanka for these loss delays? Is it simply we don't have enough infrastructure? Is it simply that people don't go to the expert law in that area, or what is it?
We don't have the infrastructure, but now it's fast developing, and we are being able to get that infrastructure into our court system. We get new computers coming in, new sound systems coming in, but quite apart from that, the public population, when it comes to a civil case, takes a little time to understand that this is a very complex issue. It's not like just doing a criminal case where you are caught for theft and trying to get you off the hook. So the client must understand, and then only the lawyer can work with the client, because as I mentioned earlier, if you need to have any documents from the client, it can't be given to you the night before the case. You will have to have it at least a 21 days before the case. So there is a responsibility on the public, I would say on a greater detail, that loss delays are caused due to them not coming and meeting their lawyer
In time. And so providing the necessary
information and documentation for the case. So you can't wholly put it on the government or any other person or the lawyers that there is loss delays. You would really look into the matter very deeply. The root cause will be that the client didn't understand the necessity to meet you, and that's what makes you to get a postponement in the case.
What would you do, in short, to do the best to your client as a civil lawyer, to do the case as fast as possible, to end the matter as fast as possible? What are the steps do you take, and what would you advise the young lawyers to, and people who are watching?
The simple thing, as I mentioned at the first initial consultation, that I ask a written document from the client in his own handwriting regarding his case. After he gives that, and I know the redress he wants, I give him another sheet of paper and ask him to write down how long his case is going to take, and what are the sections that we have to follow, and what are the steps that we have to follow to finish his case. Then he would understand how long the case will take, because this is procedure not laid by us, it's by the Civil Procedure Code, and he has to adhere to those rules and regulations.
Mr. Fernando, thank you very much for those very insightful thoughts and giving it in very succinctly and briefly for our audience to understand, and we hope to see you once again. Thank you for joining Law and Order. That's Law and Order for you today. We'll join you next week at the same time with another special subject and a special expert like Mr. Fernando on Law and Order. Today's topic was the role of a civil lawyer. If you missed our show, you can go back to and watch our shows. Go to channeli.lk, go to the drop down menu and pick Law and Order, and you can watch our shows all over again. Have a good night, enjoy the rest of the programming on Channel I, and have a good weekend.